we get started, a little bit about our firm. We've helped over 6,000 families protect the assets that they leave to their loved ones from divorce, creditors, and lawsuits. We've also helped over 300 families implement the plans that we've designed. And why that's significant to you is because what we're going to be talking about today is kind of depressing. So you're going to want to put it on the shelf and forget about it. But what's important to you is that you're taken care of if something happens, and your loved ones are taken care of if something happens. Our firm does both estate planning and elder law. So the estate planning is the who gets your stuff when you die. Elder law is Medicaid and veterans benefits. Our firm also belongs to a lot of professional organizations, and the reason why that's significant to you is most of the time when you hire a law firm, you're getting the experience of that one attorney and what that one attorney has learned over his or her career. But by us belonging to the larger organizations, you get the experience of not only the 4 attorneys in our office, but also what other attorneys have learned nationwide. I've written 3 books. The first one is entitled Who Gets Your Stuff When You Die? The other 2 are based on Alzheimer's. One is living as an Alzheimer's caregiver. One is living with Alzheimer's disease. And if you're interested in either of these books or any of these books, we can actually send them to you. So we have a location in Denton, a location in Aubrey, and a location in Bartonville, and we can meet with you in any of those. The way you first interact with our office is you'll meet with my legal assistant, Tammy. She's been with me for 12 years now. She'll get to know your family, get to know what you're wanting to put together, design a plan, and then she'll put you with one of the 4 attorneys to go forward and to actually design the plan further. So today I'm going to talk to you about if you have minor kids, who do you want to have take care of them if something happens to you? And it's actually one of the hardest decisions for a parent. So when I first started practicing law, quite a while back, we didn't have kids yet. And so I would meet with parents and I would talk over with them, who do you want to raise your kids if you're unable to? And what I would find is people had a really hard time deciding who that would be. So when I'd been practicing for about 10 years, James and I had our first child, and we were putting together an estate plan, and I started thinking through, in the event we're not around, who do we want to raise our kids? And what I realized is I don't want anybody other than me to raise our boys. And so the conversation of who do I want to have raise my boys if I'm not around is a really hard conversation. Because the answer is nobody. I want to live at least until they're 18, able to make their own decisions. Now we've actually crossed that line now. Our boys are 19 and 21, and so if something happens to us, nobody needs to raise the kids anymore. But in making that decision, thinking it through, one of the things that I want to help you realize is if you choose not to make the decision, you may actually be creating family conflict. So in the event you don't choose who's going to raise your kids if something happens, there's a list in the law that has of people that have priority in taking care of your kids. So in the event you don't list who's going to take care of your kids, the first priority people are your parents and your spouse's parents. So those 4 people could go to court and fight over who gets to take custody of the kids. And if you think about it, if one set of grandparents wins custody of your kids, are they then going to allow the other grandparents to see them? Because if there's been a court battle over who gets custody of your kids, they probably are pretty upset with each other at that stage. Also, if you're like most families, there's some dysfunction in your family. So there's some people that you absolutely do not want to raise your kids under any circumstance. And if you don't specify who's raising them, those people that you don't think would make good decisions might end up in line to take care of them. And one of the hard things is there's a few people in the world that might decide they want to have custody of your kids because they really want access to your money. So there's 2 types of things you need to decide if you're gone for people to take care of related to your kids. One is who takes care of the financial aspect. The other is who do they live with. And that doesn't necessarily have to be the same people. So in preparing your documents, we can specify who's in charge financially and who's in charge of it's called guardian of the person, where they live, those type of aspects. And we can also list people who cannot be in that situation. And it's very important that you go through it. The other thing that I find a lot with families is they don't want to hurt people's feelings. So if they have 2 sets of grandparents that are actively involved in the lives of their kids, and they don't really want to choose one set of grandparents over the other because they don't want to hurt anybody's feelings. And what I tell people is similar to the plan that I put together prior to the boys turning 18. We did choose one set of grandparents. And now that we've crossed the finish line to where we don't need somebody to be guardian over them, our documents no longer specify which set of grandparents that was. Because we didn't want to hurt anybody's feelings by choosing one set over the other. So you don't necessarily have to have the people you're having be guardian over your kids even know that they've been chosen to do that. The other thing that's important is when you're putting somebody in charge of them financially, you may also want to look at their health. So if your parents are starting to have some trouble taking care of themselves, would they be able to take care of the kids, or would it make sense to have somebody younger be in place so that they're healthy enough to take care of them? And also looking at it, figuring out, okay, if your parents are having trouble now and the kids have 10 years till they turn 18, are they going to make it till the 18 mark in being healthy enough to be able to take care of them? Other thing that I always talk through is if you're wanting two people to be in charge, so maybe your brother and his wife, you probably need to talk through, are you wanting them as a couple or are you wanting just your brother? So if they were to get divorced, do you want your brother to end up with custody of the kids, or do you want his wife to maybe have a shot at that? Now I have some people that really do want a couple, so they'll say their brother and his wife, and then they'll say the sister and her husband, and so it's a couple each as they go down the line of people, or it could be an individual. So we've got to think through some of those kind of things. Now I've told you we can have the person that's in charge medically and of caregiving to be different than the one that's in charge financially, and so just because they're the person that would be good for them to live with, it might not be the right person for them to be in charge financially. One of my clients actually her grandfather had actually set up a blind trust. And what that meant is that this client didn't know that her grandfather had actually left her money in a trust. When she turned 25, she found out that she had money in the trust. Now, she got married at 21, and her mother had her have an extremely expensive wedding. And when she was planning that wedding for her, she was like, well, if my mom wants to spend a lot of money on my wedding, I'm fine with that. I'd rather have something kind of small and simple. But if my mom wants to throw this big affair, she can. When she turned 25, she found out her mom had actually used her money to pay for that wedding. So one of the things to look at is whether we want to separate guardian of the person, meaning where they live, medical decisions, and guardian of the estate, meaning the person that manages the finances, so that there's some sort of check and balance so the person isn't spending the money just to let them make themselves look good, as compared to really looking out for the interest of your child. So guardian of the person is one of the roles, and that's deciding where they live. So they don't necessarily have to live with the person that's guardian of the person, but that's the person who has the ability to decide where they live. It's also the person that makes medical decisions for them. And then guardian of the estate is the person that handles finances. And a lot of times it is a good idea to have the person that's handling the money be different than the person that they're living with. The other thing that we do for our clients with minor kids is something called a minor emergency card. And what it says is I have a minor child at home. In the event I'm in an accident and either pass away or become disabled for a period of time, I've got minor kids at home, and here's a list of people to call. And when you're putting together the list for this, you need to think through who's local and available. Because if you were to put a relative that's out of state and it's going to take them a day or two to get down here, there needs to be somebody for the kids to stay with, to take the kids during that period of time. Because a lot of child care centers, in the event somebody doesn't come and pick up your child by 5, they may end up calling CPS to come get your child. So if you have a list of people that are local, able to take over, and then we also might want to put together documents that allow them temporary guardianship or temporary custody of your child until the person that's supposed to take permanent custody actually comes down. So the other thing to think about in estate planning, and this is important whether you have minor kids or not, is whether you're going to do a trust or whether you're going to do a will. The distinction between the two, they both specify who gets your stuff when you die. A trust makes it easier because there's no court involvement if you pass away or if you become incompetent. With a will, there has to be a court process at the point where something happens. So the other important thing is if you have a minor child and you make that minor child a beneficiary on your retirement plans, you're actually going to cause a major problem. We just actually went through one where a father had left his daughter, who was 16, a $10,000 retirement account. And the problem with it is, under the law, the daughter was required to take out minimum distributions. But because she was 16, the investment company wouldn't allow her to take money out of there. So what we had to do is go to court, get somebody appointed as guardian of the estate, meaning in charge of the money on her behalf, so that those amounts could be pulled out. So what we recommend is if you have somebody under the age of 18 that you're leaving a retirement account to, that you leave it inside of something called a retirement plan trust. It's a trust that allows the money to be available for them, appoints somebody to be in charge, and makes it where nobody has to go to court to get authority to get in charge of that account. So other important thing is, what if your child is disabled? So when they hit 18, if they're still going to need somebody to help them with their finances, or if they have a disability and we're wanting to protect benefits. I have a seminar that specifically goes through all the details related to helping a child with a disability and protecting that. And if you're interested in that, you can look on our online webinars for it. So the other question is, once they turn 18, are they going to be responsible enough to handle their own money? And the answer for most people is no. Most inheritances are spent within a year of receipt. So whatever you leave them, no matter how much the amount, they tend to spend it within a year. And the number one answer of what somebody's going to do if they were to win the lottery is they're going to spend every dime of what they've just gotten, and they're going to quit their job. So if you don't want them to be unemployed and spend through the money, we might want to put some protections on it. So we recommend that it gets put into a trust. You put somebody else in charge until they're at least 25. They actually say our brain doesn't stop forming until 30, so it might be a good idea to wait until 30 to allow them to have control of the money. If they're responsible, you allow them to be in charge, but we can add in language that protects them if they were to get divorced or sued or have creditor problems. If they're irresponsible, then you're going to want to put somebody else in charge to make sure that it's protected. Other important thing in putting together the plan is communicating your values to the next generation. So thinking through what's important to you, what do you want them to do with the money that you've left them. So I have a few clients that will actually set their trust up to match earnings because they want to make sure the people they're leaving money to stay employed and have an incentive to continue to be a productive member of society. We have some clients that will actually set up education trusts, which will provide money for college or trade school. And if you do that, I would highly recommend that you put some restrictions on the money or some things that have to happen related to it. I have a client whose grandson actually has the other set of grandparents have already passed away. He is living off the education trust, and the rules were he just has to make A's in the classes he takes. So he takes one class per semester, makes an A in it, and all his living expenses are covered. Probably not what that other grandparent was intending. He probably intended for them to be actively pursuing a degree. So we'll talk through that. Whether you're willing to pay for in-state tuition or out-of-state tuition or any limits you want to put on that way, we can talk through that to make sure it does what you want it to do. Also, an important thing with kids, if you're in a second marriage, is protecting both your spouse and your kids. Because most people, when they set up a will or a trust, if they're married, are going to leave everything to whoever they're married to. And in the event you've got kids from a prior marriage, the odds on your spouse actually leaving money to your kids is pretty low because usually that step-parent relationship becomes somewhat strained. So if you're in a second marriage, we need to talk about making sure assets make it to the kids. And even in a first marriage, we might want to talk about it. I have a client who was married 65 years. His wife passed away. He remarried within 3 months, redid his plan to leave everything to the new wife. So just because all the kids are of the first marriage, we still may want to put in protections. Also, really important to keep your plan current and up to date. So as time goes on, we're going to need to adjust for things that happen. We like to meet with you every 3 years and just make sure the plan we put together still works. And this is extremely important if you have minor kids, because as they grow up, you're going to start wanting to put in more protections. And what I've found is if you have kids that are 11 or under, most of the time you have full belief that they're going to be extremely responsible people the moment they hit 18. If they're in their teenage years, you're starting to wonder whether they're ever going to be responsible, and thinking maybe they need to be 50 or 60 before they receive the money. And then once they hit college age, they start becoming their own adults and start becoming more responsible. So we may want to adjust the plan along the way depending on what their life circumstances are. So we would love to meet with you in our office. Like I said, your initial appointments with Tammy. She gets to know you and your family, helps you put together a plan. And the most important thing with it is we can always adjust it as time goes on, but it's better to have something in place to make extra sure your kids are protected.